Live.
All right, welcome to the House Judiciary and Corrections and Institutions Committees. This Tuesday morning, May 26th, the last week of the session. And we're going to look at what I've been calling the Burdett Amendment of S-193, although it has most of the folks from the Judiciary Committee on this particular amendment. And we figured just to be a little more expeditious, we'd to have the walkthrough jointly with the two committees. So I'll turn it over to Eric. So thank you for all your work on this, Eric.
Yes, thank you. And Eric Fitzpatrick for the Office of Legislative Counsel, as the chair of the House Judiciary Committee, indicated here to talk to the committee about some changes to draft. I hope everybody has draft 4.1 of what we're calling the Burdett Amendment to S-193. And also thanks from me as well for having this as a joint committee hearing. So that would say the same thing twice right down the hall. I appreciate that. Thank you. But also on that note, I have gone through this amendment with both of these committees last week, draft 4.1. But there's some changes to it. So I'm going to focus on the changes rather than reviewing this. As you know, it's a lengthy amendment, but I'll give you the big picture for a moment to remind everybody maybe why this is such a lengthy amendment. And that is because what the proposal is to do, you may recall, is to have two different effective dates for the statutory provisions regarding people who are placed in the forensic facility. And you're going to have one effective date that is in version 4.1 of this amendment. And that version of it still has the Department of Corrections being involved in the provision of security services, supervision of people who are released from the facility, et cetera. But that those substantive pieces and the underlying policy is only in effect for 3 years, right? Because then at the end of that 3-year time, July 1st, 2029, the proposal rests on the idea that at that time is when the permanent forensic facility will be ready to go. That will be operational at that time. Again, that's if things don't turn out exactly the way that the plan is, you have 3 years of time in which to do some amendments to the underlying language. So, but that's the idea. So then in version 7.1 of the committee amendment coming out of House Judiciary, that has the versions of that same language without DOC involvement, or at least I shouldn't say without, with the guardrails around DOC involvement that are not in the Burdett Amendment. And then that version that came out of House Judiciary, that's that deferred effective date. It doesn't go into effect until July 1st, 2029. So in theory, everything works great. And also in the meantime, remember, there's emergency rules that have to be proposed by the Agency of Human Services that will govern how and this is also important, that because in that interim 3-year period, the forensic facility is not yet in effect, right? It's not yet running. So it's not referred to as the facility, it's referred to as the Forensic Competency Restoration Program. Because it's the program that DOC is going to be running, proposed consistent with the statutory language and via these emergency rules that are going to have to come before the Joint Justice Oversight Committee. Well, they'll have to do 2 interim reports as to how they're doing. But I think the rules themselves have January 15, 2027. They have to have them proposed by that time. So that's the overlying structure, right? It's 2 different time periods of when these 2 different provisions become effective. I went through all that last time. That's just a refresher, but it also helps to understand what the language changes are between draft 4.1 and draft 3.1, which you reviewed last week. So with that being said, I'll go through what the changes are unless anyone wants to jump in before I do that.
I just want some clarity.
Yeah.
In the interim, as well as the long term, DOC is only providing security. They're not providing any competency restoration programming. Is that correct?
Well, it's correct that they're not providing competency restoration, but in addition to security, they are permitted to do some supervision of people who are released.
Correct, but I wanted, because I don't want my committee to think, because there was a statement made that DOC would be doing the programming, and they're not doing the programming. They're only doing the security.
That's my understanding.
Okay, I just want that to be clear.
In the interim, you mean?
And in the interim as well.
Exactly. Okay. All right, so let's take you see, these are broken up into instances of amendment. So version 4.1, we're looking at page 1 a very small change to the legislative intent language, and that is on the lines 11 and 12. This is just making clear, consistent with what I just said, because this legislative intent language sets forth that sort of bifurcation of responsibility between DOC and the other departments within the Agency of Human Services, and clarifies that, hey, DOC doesn't, other than providing security, it doesn't otherwise operate or staff the facility. But remember, that principle only goes into effect July 1st, 2029. So that date is added on lines 11 and 12. The intent of the General Assembly to establish and operate the forensic facility by July 1st, 2029. So just clarifying that that's what this applies to. Second instance of amendment starts on the bottom of page 1, goes over on page 2. This has to do with that feasibility plan that the Agency of Human Services has to come back to the legislature with. And over on page 2, you'll see what's struck here, and it comes back in later. This is the subdivision 12. That's again taking into account the fact that there's this plan that has to happen in the interim, right, during those 3 years before the facility comes online. And one of the things that the committees wanted to have happen during that period of time, see subdivision 12 there, is have opportunities and cost assessments for people who would be eligible for placement at the facility while the facility's development is pending. So in other words, otherwise they would qualify for it, but there isn't a facility yet. So what happens then? You wanted to have the option lines 3 and 4 for placement in an out-of-state residence where clinically appropriate programming can be provided. Now, what's not here, which comes back in later, there was another piece that you wanted to, that's related to the interim plan, that you would have the DOC available within a correctional facility that's not under contract with DOC, that this competency restoration program could be provided in that setting as well, in the interim, not in the long term, but in the interim. But that's not here in the feasibility plan, but you'll see later on, it's in the rules that required in the emergency rules, DOC or AHS is required to address that issue in the emergency rules. All right, third instance of amendment starts on line 5, page 2. This also has to do with the feasibility plan. And this is also related to the emergency rules that have to come out by January 15th. But remember, the Agency of Human Services has to come to Joint Justice Oversight at, I believe, August and November meetings, if I remember correctly, and give them updates on how this is going. And so this proposes to add to what they're required to update JJOC on. You'll see line 6 to 9. They have to also update JJOC on how the emergency rulemaking is going, right? Which makes sense because the rules don't have to get done until January, but you've got 2 other JJOC meetings before that, well, at least where they have to update them on how it's going. And also, starting on line 7, in addition to the emergency rulemaking update, including a budget estimate for the period from January 1st to June 20th, 2027, that includes sources, use of funding, staffing levels. And that budget estimate is for that interim program. And I should point out that language, line 7 to 9, starting at the word including and going to the word levels, is from the House Appropriations Committee. And I ran that by JFO people, and they said, from a technical perspective, they said that language. So that's where that comes from, just so you know. The fourth instance of amendment, this is one where there may be a change later on, a moderate change, but this is the idea that, and this is also, I should say, this is the House Appropriations Committee amendment right here. This is the fourth instance of amendment, starts on line 12 and goes over onto just through the end of this page. And this is some limitations on the permanent forensic facility during the planning stage, and also clarification on the interim program. So subdivision C1, that paragraph says, all right, well, unless the General Assembly does something in the meantime, the Agency of Human Services shall not advance the development of the permanent forensic facility other than what is required to complete the feasibility plan required by this section. So other than the feasibility plan, what House Appropriations was concerned about was they didn't want AHS or DOC starting to engage in any contracts yet for the permanent facility. They wanted the progress reports to come back first. They wanted the interim plan to get started first, and then the legislature will be able to look at, well, should there be any permanent contract that gets going? So that was the purpose of that. But subdivision 2 is kind of say, well, that's not to affect the interim program, because you see what it says. No further legislative enactment shall be required to implement the interim forensic and competency restoration program. So you see the distinction there. Because the interim one has to get started quite quickly. Same for that one. You don't, not required to wait for the legislature to say anything more about that one. You can go ahead and get started. But it does say in the second sentence there, that interim program is contingent on the availability, of sufficient resources, including appropriate staff and medical. So all that language is from House Appropriations. All right. So that takes us to the fifth instance of amendment on page 3, and that actually is all the way through the last pages 3 to 26 is this fifth instance of amendment. And the reason for that, because that's obviously a lot of pages there, you may recall, that's what I said earlier. The reason is because this reprints the entirety of the 2 substantive sections about people who are found not competent to stand trial and not guilty by reason of insanity and who are placed in the facility. But it reprints the entire sections that are in version 7.1, which has House Judiciary, with one change that has to be made in many different places. So rather than doing all these, a dozen instances of amendment, or actually probably more than that, it just reprints the whole sections and makes that change each time. And that change is the one that I mentioned. Well, actually, before I get to that one, it also, these 2 amendments also incorporate the amendment from the House Human Services Committee that, and I'm sure hopefully the committees will recall this. I mean, we talked about this last week. This is the idea that I referred to it as a decoupling of whether when someone qualifies for placement at the facility. Remember, it has 2 things that are required: a qualifying condition, and the fact that the qualifying conditions essentially shorthand makes the person dangerous, but it's a substantial risk of danger to themselves or others, that kind of thing. But do you remember the version that passed out of House Judiciary required that the danger be as a result of the qualifying conditions? Qualifying condition as a result of that's what it is that makes the person dangerous. So the change that the Human Services Committee had proposed, and which is now incorporated into this amendment, is that rather than requiring causation between the 2 things, it was just that the person has to have the qualifying condition and they would be a substantial risk of bodily injury to another person if they were released. So it doesn't necessarily have to be that the qualifying condition causes the danger, but they both have to be present. So that appears, you recall, throughout the bill, time and time again. So again, rather than make those as instances of amendment, it just reprints the whole section. In fact, just to see an example, if you look at page 3, line 12, there's the first example of it right there. So this is a quality. What is that makes a person eligible for the forensic facility? You see, and this is within the universe of people who are not held without bail. They have to, starting on line 12, have a qualifying condition, and it has been determined that the person's release would create a substantial risk of bodily injury to that person. Rather than saying, as the previous version did, that it has a qualifying condition that makes the person's release a substantial risk of bodily injury. So you see the distinction there. So that's made throughout these 2 sections, and you'll see it repeated the number of different times. All right. So I'll go through real quickly then, because there are a number of other amendments that were in the House Human Services Amendment that are also all incorporated into this language. And I should also add that I believe that those changes will be proposed on the floor, and they would apply to the versions of 7.1 that are going to be in effect as of 2029. Does that sound right?
Yeah, amendment will be
Right.
separately, right?
Exactly. So these same changes are made here for purposes of the interim statutes, the ones that are in effect for 3 years. And then the proposal will be a floor amendment, it's in the calendar today, actually, that will be made to the underlying provisions of 7.1 that will be in effect as of July 1st, 2020. The next one of those happens to be on page 5, lines 14 and 15. This is the forensic risk assessment that the court has to order when it determines that someone's competency is not restorable. Just clarifies on line 14 and 15, you see there that risk assessment has to be conducted in the new languages by an evaluator appropriately qualified for the qualifying condition of the person. So that's new there. It goes on to say that includes and it itemizes a number of different things that have to be in the risk assessment. Over on page 6, line 2, including in a community-based placement. That's the new language. That's because that's one of the recommendations that has to come from the forensic risk assessment has to do with treatment and supervision. This just clarifies that it has to include, it can include, but not required, that there has to be a community-based placement, but it has to be at least part of the recommendation as to whether or not that might be appropriate. Same thing, exact same language on line 17. You'll see that including in a community-based placement, is that that has to do with the court's order based on the risk assessment. Over on page 7, lines 9 through 13, that's new to this version, but also from the Human Services proposal. And this is the idea, you may recall, this is when someone is found non-restorable and dangerous, they stay in the facility, but they have this 12-month review. This adds it to the 12-month review, as well as anytime the medical director determines that review might be appropriate. But this adds a third provision that the person themselves can petition for a review as well, anytime after 90 days after the initial order, and then anytime within a 6-month period after that. So every 6 months after that, the person can themselves file a petition if they think they can show their release would not be dangerous. Another example, you see line 16 and 7, and the state's attorney has to demonstrate that the person has a qualifying condition, and it's line 16, and the person's release would create a substantial risk. Remember in the House 7.1, it's that the person's qualifying condition that would create a substantial risk. And that actually jumps forward to page 12. Subsection G on page 12, this is the compliance. Remember, when someone is released from the forensic facility, they are released on supervisory conditions, and their supervision has to be monitored by the way the language is now, the medical director, HCI, the Human Services medical director, in consultation with whatever department it is that would be supervising folks, depending on their qualifying condition. And so this adds another instance. You'll see lines 11 and 12. Person has a qualifying condition, and so that used to be that. Same thing on lines 18 and 19. Another example of the same thing. And that's it for that section of the bill.
Larry?
Yeah,
I have a question.
right.
Can you go back to sure I'm on the right page. If you go back to the forensic risk assessment on page 5 that's being done, I'm trying to follow all these changes here. Prior to the date of the hearing, the court shall order a forensic risk assessment. So does that forensic risk assessment carry through? Person is released to the community and then will be supervised by DOC?
Does it carry through in the sense?
Does it carry through? Yeah, does it carry through? There's a forensic risk assessment. So when a person is supervised out in the community, there's usually a risk assessment that's done. So DOC knows what level of supervision to do.
It does carry through. It's
It
over on
carries through.
page 6, line 50. So the conditions have to be consistent with the person's risk assessment. So that's what they use as their guidepost.
So is it clear that DOC would have access to that forensic risk assessment?
I think so, but you could always clarify that if you thought.
It wouldn't be related because it's done within the area of healthcare and human services. DOC hasn't done it. Is there any HIPAA concerns that would not be shared with a probation and parole office? Do we
Not
know?
But if the committee wants to add something, that's also.
Well, I just know when DOC does supervision out in the community, it's based on a risk level. And it's when DOC does the supervision in the community, based on that risk level, it determines how many times P&P checks in with a person how that check-in is. It could be a phone call once a week or once a month, or it could be an actual visit to the person's residence, or the person has to come into the P&P office. So I'm just wondering how all that would work out in DOC's world compared to Agency of Human Services world. Just asking.
Yeah, it's not an answer I have at the moment. I get a question.
Just to follow up on that real quickly is at page 25, the first three lines, part of the agency rulemaking is meant to address that information need that Department of Corrections would have. And I think Teresa, you had a question?
That was it. That was just.
Okay, thanks.
Just
Yeah.
on page 12, Eric, line 18,
Yeah,
is it missing, are you missing the word and, but where it says evidence of?
it is, yes.
Okay.
Yes, you've got that in a technical.
Okay.
Okay. Moving forward.
Great. All right, so we had gotten through section 10. And next change, I believe, is that now you remember there's a section of the underlying bill that is general provisions about the forensic facility as well as definitions. That begins on page 19. And the change you look over on, actually it's on page 20. This has to do with the definition of a forensic facility. Because you will recall that for purposes of the interim 3 years, for those 3 years before the final facility comes online, it's not actually a facility that's being operated yet. It's a forensic program with competency restoration services that DOC is operating. However, the language of the entirety of these two statutory sections use the term forensic facility many times. So the proposal here is to clarify, to see the first 3 lines of subdivision B. So as used in these two sections, forensic facility means the interim forensic and competency restoration program established by the emergency rules that are adopted later on in the bill. So anytime that term comes up within these two sections, it's actually being defined here to mean that interim program. And that works because this section, as well as the other two, are only in effect until 2029, which is the same amount of time that the program is in operation. And then in 2029, what comes into effect at that time, this same section of law that's in 7.1 does not have that language. See that? So in that case, when it happens on 2029, the forensic facility will be defined as, you won't see those words there. It'll just say forensic facility means, the locked secure facility where, et cetera, AHAs provides services, et cetera, because at that time you'll have the forensic facility. At least that's the plan. So to sort of drafting sleight of hand, you might say, but it uses that definition that will cover the first 3 years, and then starting in 2029, the operational forensic facility definition becomes better. And you may recall also discussion that was had last Friday, also on page 20, some language that struck on line 3. It had said, which shall be a locked secure facility that provides a suitable clinical setting. And I remember the committee was discussing, House Judiciary Committee was discussing, what's suitable, who's making that decision. It seemed like language that wasn't capable of easy interpretation, and also wasn't actually particularly helpful because you realize that, well, aren't the really operative substantive requirements of this, in this case, program facility, really in Romanettes 1 and 2, where it specifically provides for what AHS has to do.
Eric, where are you right now?
I'm on page 20, line 3. And it's after the word, it doesn't appear there, but it's defining forensic facility, and then line 3, which shall be a locked secure facility. In the prior version, it said right there, that provides a suitable clinical setting. So those language words are gone. And instead, you're just relying on the operative requirements of the agency to when it operates the program.
Before you go forward, Teresa?
So I guess I'm just wondering, in the program that's being developed in the interim, it seems as though we want it to be within the facility, if there is such a thing, a suitable location within the facility. I think we've all heard testimony that from corrections that folks would just be in the general population. And I'm not sure that's going to be suitable towards competency restoration or services that are envisioned in this temporary program. Just a comment.
Well, our committee was really concerned that in the interim, the folks that are being held in our correctional facility are not being held in the general population. We wanted to make sure they were in a safe environment within that correctional facility. But also, we didn't want to lay the groundwork that that's where the forensic facility would be long-term. So it's a balance that we're trying to achieve here.
I think that part of it was, we didn't want to suggest that within one of the facilities, there could be a appropriate clinical location, at least in this interim, because we didn't want to make that suggestion going long-term that it would be appropriate for the long-term solution. That makes sense.
I understand that, Marcy. Mel heard testimony 2 years ago when this very same people who are here advocating for this now from the administration said that the people that they were holding in corrections were being victimized in the settings that they were in the general population. So I'm just pointing that out, that I guess I don't see, I guess it's a wait and see, I guess, and I'll just be honest, I don't have a lot of faith in the current process to yield what it is that we think that we're doing in this.
Yeah, I think it'd be a question for Alice, and I'm just one. And I think I know the answer. Are they being held in general population now, or are they in a clinical setting?
They're not in a clinical setting. There is no clinical setting in DOC in a correctional facility. When you talk about general population, that's where folks they can move freely within a certain unit. There are certain situations in a correctional facility where folks are aging out, and there's a lot of mobility issues or dementia. They will tend to be housed in a separate unit. So the concern is, because we've heard some testimony from DOC, that those folks, the folks we're talking about here in this piece of legislation, could be put in general population, which is really troubling because they could be victimized and they don't have the capacity to understand where they are. So we want to make sure that they are taken care of. And I don't want to say the word protected, but there's assurances that they are placed in another part of the facility besides general population. DOC is not going to be offering them clinical services. It's not a clinical setting whatsoever. It's a living unit that's been put aside. That's all.
Oh, yeah.
I appreciate that distinction. And I wonder if we can say that. Like say something without, I understand the concern about calling it a suitable clinical setting, and it's really, taking that out is really, I think, meant to acknowledge that a DOC facility is not going to be a suitable clinical setting. So appreciating that, is there language we can add in that would talk about that, make explicit the need for separation?
Separate living unit from general population. I don't know, just put that out. Or
I mean, we've heard very clear testimony from the Commissioner of Corrections that there's no intended renovations. There's a very, to me, sounded a very confident statement that they're just going to be housed. He named the units very specifically where they would be housed. I've seen those units. I've seen inside those units. There's nothing therapeutic, there's nothing clinical, that it's a jail cell. And I share the Chairwood's concerns that I don't want to put words into the chair's mouth, but my concerns parallel hers in that we are creating what's called here an interim facility, which means a program. And we are just setting up 3 years from now the ability to say we're doing just fine, because that's kind of what we've been doing all along anyway. We're already doing it. And what we're already doing is not forensic, it's not treatment. So I was one of the strong proponents of taking this language out that Eric just referenced, because it wasn't honest. It wasn't honest at all. We are going to be housing folks who need forensics treatment within a correctional facility that is not at all clinical or therapeutic. That is what we will be doing for the duration of this program. And we have heard from the Commissioner of Corrections that there are no intended renovations or anything like that. So that's what we're doing. And I just want the language to be honest about that.
So I appreciate that and wonder still, is there, and you using the word unit, does that mean, is there separation? Is there planned separation, physical separation, or, I know there are, as we all know, there are restrictions on when juveniles are held in adult facilities. There are strict separation rules. I'm not suggesting we go to like sight and sound separation necessarily, but is there something we can say that at least makes clear that that folks should be separated to prevent the type of treatment, victimization that Chair Wood and I think Chair Emmons referred to?
They're in the way the correctional facilities are designed, at least one of the living units are broken up into different pods, basically. So one of those pods right now is housing folks with dementia. They're not there. They haven't been deemed incompetent. They have stood trial and they have a sentence, and that's being commingled with detainees who may be incompetent to stand trial. So it's a separate pod within a bigger building. And the pod can hold up to 20 beds, 20 cells, around 20, because it's two levels. You got a big community room on the first floor with cells around that. Then you got stairs that go up to another loft, like with cells. So it's a locked unit within a bigger building. But they have to go out to access the infirmary. They have to go out to access the dining hall. They have to go out to access exercise in the gym. But they're housed separately, but it's not clinical. It's not a clinical setting whatsoever.
And they're full now. All of these units are full,
With a
beyond
mixture.
full, because we have 150 people in Mississippi right now. So if we're going to create some of these units to be exclusive to this population, we have to move those folks somewhere. I don't know how this will play out, but right now, we're beyond capacity everywhere. So.
I just don't feel like I'm hearing an answer to my question. I don't mean to push like.
You want language in there.
Is there language we can add that I hear that like we think this is the plan, but can we dictate the plan at least a little more clearly so that folks are being separated and separate, like, I don't know how in the weeds.
So the Department of Mental Health will tell you that they don't necessarily want them segregated, that isolation then becomes a comparable problem. So I think language like that is possible. I just don't know if it's going to be implementable.
So in the emergency rulemaking, page 24, subdivision A1, perhaps there could be a little bit more there, but clinically, it's requiring them to adopt rules for, so that would be clinically appropriate standards governing the provision of services in the program. Presumably, appropriate standards would include where the individuals are, if there's the separation. We need to expand that, or do we need to keep it broad enough to capture that or other issues? That would be one question I have.
What lines are you on now?
Line 14, 15,
There, thank you.
Yeah.
or that whole subdivision, actually.
Placement within a facility.
Yeah, I mean, we could add placement within a facility just to make that clear.
Is that a agreement to add those language, those words?
No.
Because there will be another version of this amendment, because there's a couple of technical corrections that have to be made, including the missing and. And so they'll be in this will be the 5.1 before it gets, because obviously this one is not in the calendar. It's gonna be distributed on the floor later, so there's still time to make some changes. But
Yeah, no, I think that helps. Yeah,
it's repeat.
So it will be on page 24,
Yeah, I know where, yeah, exactly.
lines 14 through 18.
Yep.
That there would be a statement added that the rules would also need to address placement within the facility.
it's after the including, and we'll add this to the list that we want to include.
Right. So patterns and ratios, semicolon, staff qualification, et cetera.
Placement of the person, placement of, you gotta qualify what placement we're looking at. Where the person is placed.
You want it to be specific to general population, within general population or not?
No, I don't think so.
I think
No, I think you better, we have to be clear. You're talking placement of what? It's placement of a person.
But are you suggesting that this could vary from person to person, or are you suggesting just talking about one program in one place, whatever that place is?
We're talking about the program. It's the rulemaking for the program. I don't know, I just, maybe
We're
you
talking
don't
about
want
all
to
people who qualify.
call people for folks with the qualifying conditions.
So
Something,
where the person is placed within the DOC facility.
Karen,
I think you want to,
Just as we're finalizing, I just want to share, if we could get into the weeds on this, and I don't know if micromanaging it so much is going to be helpful for DOC. I feel like their intention is to do the work. These folks are already within DOC now, and like this program is this bridge that we're talking about. And so I feel like we can give some guardrails for them, but this is not the program or the facility that's going to be there. So I just feel like we can put some in, but I don't think we want to spend the time to really micromanage in such detail. And I really support this bridge work because I'm going to be advocating in the 3 years that we are going to get to the facility piece of it. So I just want us to think about that this is a transition.
I still think that this one,
Yes, I agree with this.
this one's good, but yes.
Maybe not getting specific to general population versus.
right,
Think about unit placement is great.
It's like, where are they going to be in the facility? I think that's an
Right,
important
that's-
point.
James?
Yeah, I'll make this quick. I don't get the opportunity to agree with the assistant minority leader very often, but I would like to wholeheartedly agree, even though she's not listening to me, agree to it. I'm telling you, like, if we get overly prescriptive at this late game, people have been here longer. I've been here 8 years. It's been an issue perennially. People have been here for 10, 15, 42. This has been an issue. And it's always fallen apart. You either take the step and hope for the best, and what we all, I think, but the majority of us, at least, I can't speak for everybody, want a real facility eventually. This outlines how to make that happen. But if you push for perfection now, it's gonna happen exactly what every other bill people push for perfection on. It will die. do not let perfection get in the way of a step that needs to be taken.
Well, judiciary usually has perfect bill, just so you know. But that's okay. Yeah.
I understand.
So are we doing language that talks about placement within the
The
facility?
way I've written now is where the person is placed within the Department of Corrections facility.
Oh, good.
Sounds good. On that same page, page 24, although it's not there, you also may recall, up at the top of page 24, there had been a provision in the general language that had required Agency of Human Services rulemaking. Remember that? But that didn't make sense because this is the interim program that's only in effect for 3 years. That's going to be governed by the emergency rule. You want to have two different sets of rules in effect. So that provision is struck. It's not there anymore. But it is in the statute, the version of the statute that's going to be effective on July 1st, 2029. It's still there because at that point, you do want AHS rules governing how the facility operates, but you don't want two sets of rules that could possibly say contradictory things. So that provision is struck here. Also on page 24, you'll see line 15, referring to, again, to what's going on here in this interim status is the Forensic and Competency Restoration Program. See those words on line 15. Previously, that had been forensic facility, but again, there isn't a facility yet. This is the program that's in effect for 3 years, so that's correcting that language. Over on page 25, subdivision 4 is new, lines 4 through 8. This is what I referred to earlier. Remember, this concept had originally been feasibility plan. And this is the idea that while this interim program is in effect for 3 years, you want the rules to also address whether or not, it starts kind of on line 6, competency restoration services can be provided within the Vermont Correctional Facility, provided by an entity that is not under contract with DOC. So that language was taken, previously been in the feasibility plan. Now it's required that the rules address it. And that's it. No changes to over the picture. You have appeals and the effective dates. That sets up the timing of the way these provisions are implemented that I discussed earlier. Some pieces effective July 1st this year and other pieces effective in 3 years. And those are all covered by those staggered effective dates and repeals.
Eric, just a clarification, probably just for me, but on page 24, on line 12, competency restoration program,
Yep.
down below on line 15 says the same thing. Does that interfere any way with the new definition of facility?
No, and actually, I think the idea is that they're, yeah, it actually is consistent.
Okay.
So under the new definition, that also says means the interim forensic and competency restoration program established by those rules. So they're kind of referring to each other.
Okay.
I got more questions on my side. Troy, James, and Kevin.
Back to page 25, line 4, so in section 4. This is not a requirement that the agency providing competency restoration services shall be separate from anyone currently under contract with the Department of Corrections. This is just asking us to consider what the estimates, what the opportunity for that is.
In the feasibility plan.
In the
Rules.
right, so there's no requirement here that those services are provided by somebody who's not currently under contract with the DOC.
Yes, that's correct. If I stated that unclearly, that's correct. It's only that
Right.
the rules address the possibility.
Right.
And the opportunity and what the cost might be, but not a requirement.
May be alone in this, but I am very interested, and I have been from the start of this, that anybody providing competency restoration services shall not be under the contract currently by the DOC. I think that's a significant conflict of interest. And I don't see anything in the bill right now that would make that a requirement.
We thought it had been in there, so.
Yeah, it had been at one point. It had.
Yeah, I don't think, okay.
I don't know the corrections world, but would that limit us as far as potential providers?
Well, it would be up to the Agency of Human Services with Dale and DMH to look at providers that could provide.
Yeah, I don't know how many providers are out there in that world.
They'd have to go out with an RFP for bids. Because the real concern, the way the structure of the bill was, DOC contracts with WellPath.
Mhm.
And if WellPath is providing the restoration program, they have to also answer to DOC, and DOC is not the appropriate entity to provide clinical services to folks who are not competent to stand trial. So we really wanted a wall
Oh,
between
okay.
DOC and the contractor. Because it was sort of the fox garden and hen house. You had WellPath. Because they answer to DOC. The DOC doesn't provide the clinical services to these folks. So
It's a
I,
policy decision for you, but just so you know, language wise, it'd be easy enough. You could just say, provided that the entity provides the services shall not be under contract. So you could phrase it that way if you wanted. If you prefer to have it prohibition as opposed to, but consideration. Policy decision, you guys.
does that make it better? Does it clarify it, that there's a real separation? Can you read that language again,
You
Aaron?
could phrase it as provided. So in other words, you're kind of using the same word but with a different meaning. Because it's provided that so long as, you're using it in that context in this way, provided that then you go to entity, provided that the entity that provides the services, because the services are referred to in the previous clause, that provides the services shall not be. And then go back to under contract.
I mean, you're still just evaluating whether or not that opportunity exists. You're not requiring that this interim forensic program contract with competency restoration group that's separate from anyone under the current contract with the DOC. Right, we're still talking about exploring the opportunities and cost estimates of what it would be like if we required that. You're not making a requirement, you're asking for the consideration of that requirement. Here's the thing, I'm gonna be very transparent. I am not in support of this amendment. I am not in support of this bill as amended. So do with that what you will to the rest of the committees that have to make these decisions, but I think that's an important consideration. Even with that consideration in, I am not in support of this bill or this amendment. I think we're setting ourselves up to do nothing more than house forensic patients within the Department of Corrections, and I think that's abhorrent.
Kevin?
As written and discussed, how does this affect our use of any federal funds that are currently?
Federal funds coming into DOC?
Yeah, Medicaid. How
Or
does
the
this,
waiver,
yeah,
the one
does
fifteen
this help
waiver?
us maintain those funds, or do we lose funds because of this bill?
The 115 waiver is only for, help me out here, Teresa. I think it's only for folks who are sentenced. So they also, is that also for folks who are detainee? You can't, you get a 90-day window there
Yeah,
prior to release.
prior to release, the only thing that, you will not, the state of Vermont will not be able to receive Medicaid funds for anybody while they're in the facility or even in a forensic program with locked doors. That we will not get any Medicaid for that. That will be 100% general fund. The only time Medicaid comes in is, guys, Chair Evans was saying, is during this window of potential release to a community-based program. We actually do draw down Medicaid for community-based secure services in the community. But we're going that by doing this in the institution setting. So this will be all state funds.
This will be all state funds because of these changes.
No, it just not because of these changes, because it's in a locked facility.
Okay, so this doesn't hurt our funding situation. This is at least neutral.
I guess I'm not sure what you mean by neutral, anything, it doesn't hurt, but we're not gaining any
No,
Medicaid
I
funding.
understand, but it doesn't hurt. Because we're currently taking care of these people one way or the other. This is far from perfect, but it's better than what we currently have, because we are allowing programming to be added to the services that these 10-ish people have been receiving.
But
I
they
don't know
haven't been,
the funding though, is what I'm.
It will be all state general fund.
yeah, and it'll be coming out possibly of Department of Mental Health or Dale, because folks right now are not receiving services. So if you're gonna contract out for a provider to provide competency restoration programming, those respective departments that are contracting out with a provider is in their general fund budget. So their general fund budget will be increased to provide the program. Unless they're saying they can absorb it in their budget. That might help us, their general fund budget, when they propose the FY 28 budget, there'll be an increase in general fund requests. Yes. Yeah.
Sean,
Oh,
So are
sorry.
we okay with, I'm okay with that, you know, the sentence that's provided that the entity shall not be under contract with the Department of Corrections. Can we get that nailed down and move on from
It's a
there?
little clarifies it.
Okay,
All right,
so
I would like that language.
yeah, no, that sounds good.
okay with that,
I'm okay.
okay.
But like I said, my main concern is that it's not gonna limit us going forward as far as the number of providers out there.
No,
It doesn't sound like it.
yeah,
I don't have anything more, so at the end of, yep.
So I think it would be helpful if my committee went back up in our room and had a conversation.
Yeah, so we're gonna have version 5.1, which is gonna implement this language, there's a couple other technical changes.
Yep.
So hopefully later this morning, we'll have that possibly. And also are dealing with the appropriations language that Teresa had. And I'm hoping that that's gonna be a separate amendment coming from Trevor Squirrel from appropriations as opposed to being in here.
Teresa's, no.
That's not what they want, but, I didn't,
Yeah, go ahead, but yeah. please.
I think, Katie is working on language and I want to be transparent. The language that appropriations put in their first, paragraph of that, essentially says that no planning can happen for the future forensic facility, until the legislature has another enactment of something. There is a lot of planning that could happen for the future forensic facility without it costing additional funding. And so I am trying to modify that language, and Katie is working on that to just essentially say you can continue to plan within the confines of all the rest of the stuff, emergency rulemaking and, you know, reports to joint justice oversight and not expending funds. So they can be looking, I mean, I think we all know this is probably gonna land on the site of some correctional facility someplace in the state. And so there's planning that they can do without having to incur costs. And so I do not want to delay that another full year, essentially, till we have another budget next year.
Right.
So,
Yeah, so
would that be in this amendment or a separate amendment?
I think that remains to be seen. It depends on what appropriations does. I had suggested that they put it in a different amendment, but
They
maybe if,
prefer it in this one.
right, so that'll be a discussion with,
If the committees are okay with keeping it in this one, you can let the chair know.
But the chair has appropriations.
The
yes.
chair of House Appropriations has delegated that to Representative Squirrel and I.
Okay, I just want to jump in for a second, just so there's not any confusion. And I ask everybody to let both Katie and I know when there's a lot of moving parts of this, a lot of multiple amendments, it's very difficult. And also very unusual, but, so Chair Wood knows, well, I told Katie to hold off on that amendment.
Yes, we just-
Until we figured that out, okay.
And
Thank you.
she's gonna be in touch with you, Eric.
Sound good, thanks.
So I can be the traffic person for these things as well, so to make sure. Yeah, Karen.
With all this, I feel like it is very confusing. There's a lot of layers. Can you just walk us through what you see as the next steps this morning or today?
Yes, so we're gonna deal with this amendment we just talked about and determine whether it stays in here or not. And, hoping, yeah, well, so hoping that by the end of the morning, we will have draft 5.1 that incorporates just what we were talking about this morning, a couple technical things that I picked up, reading it yesterday that Eric has. So by the end of the morning, we'll hopefully have something we can review and vote on.
Both committees.
Yeah, correct. That's the game plan. And perhaps it'll be on the floor this afternoon. Okay, so with that, thank you, everybody, and thank you, Eric.